General, I take your point about declaratory judgments, but I just want to press a little bit further on this same point, and that is for purposes of standing and redressability. You took the position, I believe, that vacature does solve Texas's problems because the immigration laws will be enforced differently without the guidelines than with the guidelines, right?
Yes, and to be a little more specific, there are findings of fact from the trial court that the guidelines
support that. Yeah.
Yes.
So without the guidelines, the government will enforce the immigration laws differently in a way that satisfies Texas.
Without the guidelines, yes, and just to specify a little bit, that without the guidelines, federal immigration officials will no longer view their mandatory obligations as
We can spin it out as long as you want.
I'm agreeing.
The answer is yes, right?
Yes, Your Honor.
Okay. And if that's the case, then why isn't a vacature of the guidelines enjoining, in the language that we used last term, the government's ability to enforce the immigration laws in a certain way?
In part because, Your Honor, the essence of an injunction is not whether or not people will react to it in a way that remedies someone's harm. It's that they're compelled to. Something about injunction doesn't just say, fix this person's injury. It says you must, under pain of court supervision, under pain of penalty, you must do these things or refrain from these.
Isn't that Texas's whole point, is that under 1226, 1231, the government must do certain things, and it's not doing it because of the guidelines. Getting rid of the guidelines will fix the problem. And therefore, the government is now effectively required to enforce the immigration laws differently than it otherwise would.
Those are our merits arguments as to 1226 and 1232A. Our remedy is simply because the guidelines are unlawfully causing DHS agents essentially not to treat mandatory things to treat mandatory things as discretionary. They are, as a matter of fact, reducing the number of detentions, et cetera. But our relief would not coerce them into doing anything. It's merely a matter of fact that DHS agents would so respond. We're not asking for anything coercive.
Thank you.
But they could, I mean, the guidelines are gone, but that doesn't mean that ICE officers or DHS couldn't more informally say, we're going to exercise our prosecutorial discretion not to institute removal proceeding against this particular non-citizen.
That certainly might well be the case, Your Honor. Of course, that would have been the kind of evidence that would have attacked our redressability, that had petitioners submitted that to the district court certainly would have undermined it.
But it's your burden to show standing, right?
Yes, Your Honor, and we did by, again, findings supported by clear error showing the causal relationship between actual enforcement actions and this memorandum, including, for example, 22 emails specifically citing the guidelines as a reason for removing detainers.